This isn't just a court hearing. This is a person standing alone against a system that never stops moving. You can hear it in the pauses. You can feel it in the silence. A judge reaching out, a lawyer backing away, and a defendant slowly closing every door meant to protect her. One word could have changed everything, but it never comes. From this moment on, the court doesn't argue, it records. Watch carefully, because this is how people lose cases without ever saying a thing.
Matter on the court's docket scheduled for 8:30 this morning is a motion hearing in State of North Dakota versus Londine, Ramarsha Marsalis, 02-2025 CR 252. Attorney Trent Jackson appears personally in court. Attorney Daniel Frisk appears by reliable electronic means with the court's permission. Ms. Marsalis appears by reliable electronic means from the Stutsman County Correctional Center. Ms. Marsalis, can you hear and see me okay?
All right, pause right here. This might sound routine, but pay close attention, because what starts as a simple misdemeanor motion hearing is about to turn into a masterclass on courtroom control, mental fitness, and a defendant quietly sabotaging her own case. This one escalates fast.
Yep.
All right. So in this case, Ms. Marsalis is charged with a Class A misdemeanor for stalking. Mr. Frisk has been retained to represent the defendant in this matter. Throughout the course of the proceedings, the court had reason to question the defendant's fitness. The court ordered a fitness to proceed examination. The court has recently received a report from the North Dakota State Hospital concerning the defendant's fitness to proceed, record index 54.
This is a huge legal checkpoint. A fitness to proceed exam isn't about guilt, it's about whether the defendant understands the process and can help in her own defense. Without this, the case can't legally move forward. Remember this moment. It explains everything that happens next.
While that evaluation was pending, Mr. Frisk filed a motion to withdraw as counsel. In it, the motion simply cites Rule 11.2 of the North Dakota Rules of Court. There was an affidavit filed concerning the motion indicating that counsel and defendant have experienced irreconcilable breakdowns in communications in the attorney-client relationship, such that continued representation is no longer feasible. Mr. Frisk asked the court to rule on that motion.
Translation: the judge is being extremely careful. If the attorney-client breakdown is caused by mental illness, letting a lawyer walk away could violate constitutional rights. The court is protecting the record here and protecting itself from appeal.
The court indicated that it would not rule on the motion until it determined whether or not Ms. Marsalis was fit to proceed. The reason for that is to comply with U.S. Supreme Court case law and the North Dakota Supreme Court's case law concerning the right to counsel and whether or not the impairment in the attorney-client relationship was due to any alleged mental health concerns. Since the court has now received that fitness to proceed evaluation, which concluded Ms. Marsalis is fit to proceed, and Ms. Marsalis is presumed fit to proceed under North Dakota Century Code Section 12.104, North Dakota Century Code Section 12.104.04.1 sub 1. Where we sit with this now is I'm going to take up or reconsider the motion to withdraw at this time. Ms. Marsalis, have you received a copy of Mr. Frisk's motion?
Yep.
What are your thoughts on it? Do you want Mr. Frisk to continue as your attorney? Do you want another attorney? What's your position on it?
This is where things get tense. Silence here isn't neutral, it's strategic or defiant. Courts don't operate on no response. Refusing to answer forces a judge to step in, and every non-answer is quietly stacking consequences.
I have no position.
Well, you or your family hired Mr. Frisk. Are you asking that Mr. Frisk stay on your case, or are you asking for him to be relieved?
I'm not asking for anything.
So let me ask you, Ms. Marcellus, do you want Mr. Frisk to remain as your attorney?
I have no position.
Well, I'm ordering you to take a position on the motion. I need a...
I have no response.
Mr. Frisk?
Thank you, Your Honor. As much as I like to help people. I also have a job to do and professional responsibilities. We received a letter where she feels that I'm not working in her best interest, essentially, and that she's being set up. The court may. I don't know if the court had a copy of that letter. I need a defendant that will cooperate with me in order to do my job. And I think Your Honor knows that I try to do a good job for people and I care about people. But in this instance, I'm just not able to provide my legal services. And if I'm not able to provide legal services effectively, I'd rather not provide the legal services.
And so what are you specifically asking for?
Well, Your Honor, I think I need to withdraw. She believes that I'm part of a conspiracy to set her up. The letter also says that, well, I'll refrain from that, but she thinks that I'm not on her side and obviously cannot provide effective counsel to somebody that's, one, thinks that I'm not working for them, and two, that I'm not on their side, or we're looking out for their best interests. I'm in a precarious position, so I'd like to withdraw, and I hope she finds somebody else to represent her. And I think that the letter does state that she's sufficient. She does have sufficient faculties to proceed to trial.
All right. Ms. Marcellus, if I allow Mr. Frisk to withdraw his counsel, do you understand that right to counsel still remains, which means that you have the right to hire substitute counsel? You have the right to represent yourself.
That description matters more than it sounds. Judges are trained to read behavior. What's being documented right now is an attitude, it's evidence. And once it's on the record, it follows the defendant everywhere this case goes.
You have the right to apply for a public defender, and if you financially qualify for one, you would be appointed counsel. You understand your right to counsel. Ms. Marcellus, I asked you a question. Ms. Marcellus, do you understand your right to counsel? The court will note that in the fitness to proceed examination, the examining to a mental health professional indicated that Ms. Marcellus has issues with oppositional defiance and tends to not participate when she chooses not to participate in an effort to frustrate or obfuscate or interfere with the legal process. The court observes Ms. Marcellus leaning back with her hands inside her clothing, crossed across her body. Body language is very closed off. She is refusing to answer questions about whether she understands her rights. The court again presumes Ms. Marcellus is fit to proceed. The examination presumes she is fit to proceed. Here, Ms. Marcellus appears to understand her rights, and she is refusing to participate in the process, which appears to be, although Mr. Frisk did not expressly state it, appears to be the similar concerns Mr. Frisk has about Ms. Marcellus's willingness to participate in the proceedings and assist in her own defense. Simply put, it appears as though Ms. Marcellus is capable of assisting in her own defense, but is refusing to cooperate or participate in that process. At previous times, Ms. Marsalis indicated that she did understand her right to counsel. But nevertheless, for the record, I'm going to explain the advantages and disadvantages of having counsel to Ms. Marsalis to comply with not only U.S. Supreme Court law, but very recent North Dakota Supreme Court case law. In fact, there was a case decided yesterday in which this issue was the primary focus of the Supreme Court's opinion. Ms. Marsalis, you have the right to a speedy and public jury trial. You have the right to a trial by a judge or a jury. You have the right to confront and cross-examine witnesses against you. You have the right to remain silent or to testify for yourself. You have the right to present witnesses and evidence on your behalf and to use the court's subpoena to force those witnesses to appear. You have the right to release in reasonable bail. You have the right to counsel, whether that counsel be retained, a public defender, or you can choose to represent yourself. You do not have the right to hybrid representation. You can represent yourself only if you knowingly, voluntarily, and intelligently waive your right to counsel. Dissatisfaction with counsel must not be exercising a choice between incompetent or unprepared counsel and proceeding pro se. The right to counsel must be either granted or waived in a voluntary manner. The court is familiar, at least according to the background report that the court received as part of the fitness to proceed examination, that Ms. Marsalis is over the age of 18, that she is a high school graduate, that she's able to read and write English, that she does not need an interpreter. The examination determined that she functions at 5th grade level. However, the examination also determined that the examiner believed she was putting forth less than full effort. In terms of prior court experience, the court is unaware of any prior court experiences. Ms. Marsalis has filed letters with the court indicating a knowledge of at least basic rudimentary procedure. She understands that she is entitled to discovery and has requested discovery be sent to her to the extent necessary. The court believes that Ms. Marsalis is capable of understanding the substantive law and charges against her. She has explained that she understands the nature of the charge against her and the maximum penalties. There has been no indication that Ms. Marsalis understands the rules of evidence or criminal procedure. Nevertheless, if Ms. Marsalis is allowed to proceed by herself, she will be subject to the same rules as any attorney would. Ms. Marsalis must familiarize herself with the pretrial process, including the rights and methods of obtaining pretrial discovery, pretrial investigation, pretrial negotiations for herself, legal research and writing, pretrial motions and documents and advocacy herself, preparation of jury instructions, preparation of witness preparation, or pretrial witness preparation. In terms of jury trial, if she elects to have a jury trial, Marsalis, you are responsible for selecting a jury and making for-cause and peremptory challenges, making your own opening statement, lodging any objections based on the rules of evidence. You have the right to cross-examine witnesses and to use the court's subpoena power to force witnesses to appear. You would be responsible for formulating your own questions on cross-examination and calling your own witnesses. You do have the right to testify subject to cross-examination or not to testify, and you do have the right to make a closing argument if you wish. You must familiarize yourself with the post-trial process if necessary, including motions, your right to appeal, or post-conviction relief. To make sure you make a knowing, intelligent, and voluntary choice with respect to your right to counsel, you are hereby notified that if you are allowed to represent yourself, you will be required to act like a lawyer. You must follow all substantive criminal law, criminal procedure, and evidence without any assistance from the court. The prosecutor does not work for you. The prosecutor is in an adversarial position to you. The prosecutor is trained and experienced as a trial lawyer. The prosecutor does not work for you, is not working on your best interests, and is not required to help you or explain to you any matters that might be at issue in your case. You must advocate for yourself, including pretrial proceedings, jury selection, making an opening statement, cross-examining witnesses, making objections, subpoenaing, presenting your own witnesses, preparing jury instructions, making a closing argument, and making appropriate post-trial motions. You will be given no special treatment by the court. Custodial status, meaning your incarceration might make it more difficult for you to prepare for trial. It might make it more difficult for you to contact witnesses and investigate your case. You may have limited access to telephones. The jail might not provide you with more access to telephones or law libraries than any other inmates, which may make trial preparations more difficult. Continuances will be granted only for good cause and must not be, or generally will not be granted if continuance requests are made shortly before trial. If you decide that you are unable to represent yourself, late changes of mind, requests for counsel might be denied. Your movement in the court will not change depending on whether you have an attorney or not. You will be limited in your movements in the courtroom. Documents will be transmitted to the court through a bailiff. You remain at counsel table. You will not have free access to the courtroom. Self does not give you license to abuse the dignity of the court. The court may end self-representation if you engage in misconduct or if you obstruct the trial. If you make a late decision to apply for counsel or hire another attorney, that might put your new counsel in a disadvantaged position, making it more likely that they lose the case. Misconduct may result in a restriction or termination of self-represented status. Status will not shield you from disciplinary actions at the jail, and you're subject to the same rules and disciplines as all other inmates. If you act as your own lawyer, you will not be able to later complain on appeal or in a post-conviction relief proceeding that you were providing yourself ineffective assistance of counsel. If you do represent yourself and you move forward without an attorney, you must understand that that puts you again at a significant disadvantage to those persons that choose to be represented by attorneys, whether publicly appointed or privately retained. Those attorneys are capable trial.
This is the point of no return. The attorney is out. The warnings have been read into the record, and the court has done everything required to protect the defendant's rights. From here on, any damage caused by non-cooperation lands squarely on one person.
Lawyers who would be able to investigate your case, file motions on your behalf, and provide you with legal advice based on their training and experience. Choosing to forego that option would be done at your peril. If you appeal or pursue post-conviction relief, a transcript of today's proceedings would be part of the record and considered by the North Dakota Supreme Court on whether you voluntarily, knowingly, and intelligently waived your right to counsel. Ms. Marcellus, do you understand the dangers and disadvantages of potentially representing yourself in these matters? I understand. Ms. Marcellus is refusing to answer, which again is consistent with the court's previous findings that she knows what she's doing and she's choosing not to participate and to obfuscate and obstruct the legal process. Mr. Frisk's motion is granted. The defendant has been informed of the dangers and disadvantages of self-representation. At this time, Mr. Frisk, you are relieved from your responsibility to represent Ms. Marcellus. I will leave it to you, your law firm, and your decision with respect to any refund of unearned fees as required by the North Dakota Rules of Professional Conduct. I'm not going to get involved in that issue. Nevertheless, I know that you're aware of any obligation to refund any unearned fees in this matter. Anything else from your perspective, Mr. Frisk?
No, Your Honor. Thank you. Have a good Christmas, and you as well, Trent.
You as well.
All right, Mr. Frisk, you can disconnect if you wish. You can stay on for the rest of the hearing if you wish.
I'll disconnect, Your Honor. Thank you.
Have a good day.
You too.
Ms. Marcellus, as of this moment, you're representing yourself. Again, you have the right to apply for counsel.
Okay, thank you.
You have the right to hire a lawyer. I note that...
Okay, thank you.
Okay, you need to stop interrupting me. You have the right to hire a lawyer. You have the right to represent yourself, and you have the right to apply for public defender. I've received an application for public defense services. Are you asking that a public defender be appointed?
Okay, thank you.
That isn't the answer to the question. That isn't responsive to the question I asked. Are you asking that I appoint a public defender? Ms. Marcellus, I'm going to make this clear. I'm going to review your application for public defense services, which you filed in writing. You have, throughout the proceedings, or at least on a couple of occasions indicated that you want to represent yourself. Those two decisions are mutually exclusive. Either you're going to proceed with an attorney or you're going to represent yourself. Ultimately, though, I'm going to warn you that if your conduct persists with a public defender, the court may treat that as a voluntary and intelligent waiver of the right to counsel and require you to participate on your own and represent yourself.
And you know, that's your dream anyway.
I didn't understand what you said. You're mumbling. I didn't hear you. So I will appoint you a public defender. You must cooperate with and participate and engage in the discussions with your attorney. If you continue not to engage in the proceedings, again, the court might consider that the functional equivalent of a knowing, involuntary, and intelligent waiver of the right to counsel, which would mean that you would be required to either hire a lawyer or represent yourself.
I represent myself. Yep.
You understand that now, okay? Is that right?
Okay. Yep.
All right. So review that application, and if I grant it, a public defender will be appointed, but you will not be given successive opportunities. You have the right to a public defender. You don't have the right to a public defender.
Okay. Thank you.
You need to stop interrupting me.
Your Honor, I would like to motion the court for contempt based on the defendant's conduct before the court.
Oh, I'm not going to do that at this time. So that motion is denied. Ms. Marcellus, I'm going to appoint you a public defender. Again, you are required to cooperate with that public defender. If that public defender reports to me that he or she is having the same problems as Mr. Frisk had, you might not be given another public defender. Do you understand that? Again, the court believes Ms. Marcellus understands. She is obfuscating and obstructing the legal process. I'm going to appoint Ms. Marcellus a public defender. She has been warned that she will not be given successive public defense services. She is required to participate in the proceedings. I do find that she is indigent. I'm signing that application now. Anything else? Mr. Jackson?
No, Your Honor.
Anything else, Ms. Marcellus?
Nope.
With that, we're adjourned.
By the end of this hearing, nothing exploded, but everything broke. The law gave warnings, choices, and chances again and again. Yet silence became the loudest decision in the room. Courts don't punish emotions, they document behavior. And once it's written into the record, it never leaves. This case teaches a brutal truth. In court, refusing to choose is the choice.